What just happened? In the Senate right now, Senator Schiff asked a judicial nominee one simple question. Have you ever tried a case to a jury verdict? The answer was no, never selected a jury, never cross-examined a witness in a jury trial, never argued in front of one. She's observed. She's clerked. She's drafted briefs. But she's never stood up in a courtroom and tried a case. Now she wants to be the one sitting above the jury, instructing them on the law. Schiff wasn't attacking her. He was simply asking whether she's ever done the job she's applying to oversee.
Thank you, Mr. Chairman. I just have a few questions. Ms. Westerkamp, are you familiar with the term Performance Improvement Plan, sometimes referred to as a PIP?
Yes.
Would you agree that employees subject to a PIP are essentially being notified that some aspect of their performance is unacceptable?
Yes.
Have you ever been subject to a performance improvement plan in your time at the Department of Justice?
No, sir. Senator, I've received excellent ratings.
So there's never been any issue your superiors or supervisors have had that required anything like a performance improvement plan?
No, Senator.
Thank you. Kathleen, I wanted to ask you about your experience trying cases. Have you ever tried a case to a verdict before a jury?
Senator, I've worked on a bench trial, and as a federal law clerk, I handled 7 trials.
I was a federal law clerk as well. I wouldn't say that I handled the trials. I think the judge handled the trials. But let me ask you about your experience with the bench trial. Were you the lead counsel in that case?
No, Senator, I was part of a small team of attorneys.
Were you the senior or associate counsel on the case?
Yes, Senator, I was an associate on the case. There were 4 attorneys on the case. I was responsible for helping prepare witnesses, helping second chair depositions. I also took a deposition myself. I cross-examined a witness at trial, and I was responsible for all the pretrial and post-trial briefing, findings of facts, conclusions of law.
And of the 4 attorneys, how many were more senior to you on that team?
Senator, I believe 2. There were several people who came in to assist, but again, my responsibilities, I was the primary drafter for all the briefing.
No, I heard that. I just want to understand. So your trial experience consists of being the second or third senior lawyer on a bench trial?
Senator, yes, it was a week-long trial involving complicated constitutional issues, and my role, again, was I helped draft and prepare all the briefing.
But you've never done jury selection, never done voir dire, for example?
When I was a law clerk, Senator, 5 of the trials before the judge who I clerked for were jury trials, and so I had the opportunity.
And I was a law clerk. It was a great experience, but I didn't pick the jury when I was a law clerk. I didn't question the jurors. I didn't seek to use a peremptory or other challenge for cause for a juror. That's really not the role of a law clerk. You observe it, but you don't do it yourself. And so have you, apart from the bench trial, have you cross-examined witnesses in any kind of other jury trial or any jury trial?
Senator, in that case, I cross-examined a lay witness. I also deposed an expert. And I was...
Never before a jury. Have you ever filed or argued a motion to eliminate?
Yes, Senator. I've, in that matter, handled several motions in limine as well as in other matters, particularly at preliminary injunction stage. Some of the litigation I've been involved with has had extensive evidentiary records at the preliminary injunction stage. So I've filed and handled several motions, many motions in limine, Senator.
Many motions in limine in that one bench trial?
Yes, Senator. In that one bench trial, I handled several motions in limine, but I've also handled motions in limine in other litigation, again, more at the preliminary injunction stage, seeking to establish a clear record going into a preliminary injunction hearing where there may be live witnesses, evidentiary issues, kind of at that initial stage.
Okay, thank you. I'm not trying to denigrate your experience as a law clerk. I think it's a great experience, and I highly encourage those graduating from law school to pursue clerkships, but having tried cases as an assistant U.S. attorney, it's not the same thing. To observe them and to do them yourself, I'm sure you would agree. But thank you, I appreciate it. And Mr. Chairman, I yield back.
There is a fundamental question at the heart of this exchange that goes to the very purpose of judicial confirmation hearings. What qualifies someone to sit in judgment of others? To decide their fate? To rule on their freedom, their livelihood, their families? It's not an easy question. There is no single answer. But there is a baseline, a foundation, a set of experiences that most people would agree are necessary before someone can credibly claim to be ready to serve as a trial judge. And one of those experiences is actually trying cases, not observing them, not clerking for a judge who tried them, not drafting briefs about them, standing up in a courtroom, facing a jury, and doing the work. Senator Adam Schiff, a former federal prosecutor who has tried cases himself, asks Ms. Westerkamp a straightforward question. Have you ever tried a case to a verdict before a jury? Her answer is a series of qualifications. She's worked on a bench trial. She was a law clerk who handled 7 trials. Though Schiff gently corrects her, the judge handles the trials. The law clerk observes. She cross-examined a witness at a bench trial. She took a deposition. She drafted briefs. She was the primary drafter. She was one of 4 attorneys, 2 of whom were more senior. She handled motions in limine. She's done work at the preliminary injunction stage. But the answer to the original question remains no. She has never tried a case to a verdict before a jury. Schiff is careful in his questioning. He doesn't attack. He doesn't demean. He acknowledges that clerking is a great experience. He encourages it. But he also knows, from his own experience, that observing a jury trial and trying one are fundamentally different things. Watching a judge pick a jury is not picking a jury yourself. Watching a lawyer cross-examine a witness is not standing at the podium with the weight of your client's case on your shoulders. Drafting a brief about a trial is not being in the trial. And the difference matters. It matters because trial judges do things that have no analog in appellate practice or law clerking. They rule on objections in real time. They decide whether to allow a question, whether to strike an answer, whether to declare a mistrial. They manage witnesses, counsel, jurors. They exercise judgment under pressure, without the luxury of weeks to draft a brief or consult a supervisor. And they do it in ways that can't be learned from a book or observed from a clerk's chair. Schiff is not asking whether Westerkamp is intelligent. She clearly is. She has excellent ratings. She's never been on a performance improvement plan. She's worked on complex constitutional litigation. She's drafted findings of fact and conclusions of law. She's done things that many lawyers never do. But she hasn't done the one thing that trial judges do every day. She hasn't tried a case to a jury. And that raises a question that Schiff leaves unspoken but clearly implied. How can you judge others for doing something you've never done yourself? How can you rule on objections when you've never had to make the strategic decision to object or hold back? How can you manage a trial when you've never managed one? How can you instruct a jury when you've never had to convince one? Westerkamp's experience is not nothing. She has been in courtrooms. She has seen trials. She has helped prepare witnesses. She has cross-examined a witness in a bench trial. But the gap between what she has done and what she would be asked to do as a trial judge is significant. And Schiff's questioning brings that gap into sharp relief. He's not saying she could never be a judge. He's asking whether she's ready now. Whether the Senate should entrust the lives and liberties of Americans to someone whose entire trial experience consists of second-chairing a bench trial and watching jury trials from the clerk's box. It's a fair question. It's the kind of question that should be asked of every judicial nominee. Because the federal bench is not a reward for good behavior. It's not a promotion for drafting excellent briefs. It's a position of immense power and responsibility. And the people who occupy it should have the experience necessary to wield that power wisely. Westerkamp's resume is impressive in many ways, but it is missing a core component that most judges, most prosecutors, most defense attorneys would agree is essential. She has never tried a case to a jury. She has never had to make the split-second decisions that trial lawyers make every day. She has never had to stand before 12 strangers and persuade them of anything. And until she has done the work that she would be asking others to do under her supervision, it's reasonable to wonder whether she is ready to be the one in the robe. Schiff ends his time by thanking her. He yields back. The hearing moves on. But the question lingers. What does it mean to be qualified to judge? And how do we know when someone has earned that right? For Schiff, for many who have stood in the well of a courtroom and done the work, the answer is clear. You have to have done it yourself.